All right, friends, I wanted to bring you something substantial today. Not just a quick headline reaction, not just a soundbite, but a serious conversation about leadership, integrity, and what it actually means to run for Attorney General in a state as consequential as Texas. I recently had the opportunity to sit down with Tony Box, a candidate for Attorney General of Texas, and I have to tell you, after walking through his background, I jokingly called him a quadruple threat. And then realized that didn't even cover it. If anything, he's closer to a five-time threat: military service, FBI agent, federal prosecutor, Army JAG officer, private practice attorney. That combination is not common. In fact, it's almost unheard of in a statewide race. Let's start with his foundation. Tony began serving this country at 18 years old, joining the Army Reserves while participating in ROTC during college. After graduation, he went active duty and served as an M1A1 tank officer, meaning he wasn't just in uniform, he was in one of the most demanding combat roles the Army offers. That matters. There is a difference between serving in theory and serving in the field. Command responsibility, operational discipline, accountability under pressure, those aren't abstract concepts when you're responsible for equipment, personnel, and mission execution. After his initial military service, Tony joined the FBI, and not in some quiet backwater assignment. He served in New York in the aftermath of 9/11. Think about that for a moment. The Bureau during that era wasn't operating in routine mode. It was operating at maximum intensity. National security investigations, counterterrorism priorities, intelligence coordination. This was a defining moment for federal law enforcement. Being part of that environment shapes you. It forces clarity about mission and integrity. From there, he transitioned to being a federal prosecutor, and not just white-collar work. He prosecuted drug trafficking, gun crimes, violent offenders, and later complex financial cases. If you understand prosecution, you know that's a wide bandwidth. It requires judgment about charging decisions, ethical obligations to disclose evidence, discretion in plea negotiations, and the humility to decline cases that don't meet probable cause standards. Then, after leaving the FBI, he did something that speaks volumes about mindset. He rejoined the Army Reserves, this time as a JAG officer because he now had his law degree, and he volunteered to deploy to Iraq. Later, he volunteered again for Afghanistan, serving nearly a year there as a Department of Defense civilian. That pattern, volunteering for hard assignments, tells you something about temperament. Now, why does this matter for Texas? The Attorney General of Texas is not just another political office. It is the chief legal officer of a state with more than 32 million residents. Texas has one of the largest economies in the world. The Attorney General's office litigates against the federal government, defends state statutes, oversees consumer protection, handles massive civil enforcement actions, and can influence national legal trends. This isn't symbolic, it's structural. Tony's central argument for running is about restoring integrity and depoliticizing the office. That theme didn't come out of nowhere. Texas politics over the last several years has included federal indictments, impeachment proceedings, lawsuits from top deputies, and multi-million-dollar settlements paid by taxpayers. When the Attorney General's office becomes defined by scandal rather than service, public trust erodes. And here's the thing about public trust. Once lost, it's extraordinarily difficult to restore. Tony's view is that integrity must be institutional, not personal. It cannot depend on who occupies the chair. It must be built into culture. He referenced how, during his time at the FBI under Director Louis Freeh, the Bureau emphasized nonpartisanship repeatedly and explicitly. The message was reinforced daily. The FBI is not a political instrument. It follows evidence, period. That is a stark contrast to what many Americans perceive today at the federal level. We spent a substantial part of our discussion examining what is happening inside the Department of Justice and the FBI right now. There are reports of agents being fired after participating in investigations involving politically powerful figures. There are prosecutors allegedly pressured to bring cases that grand juries reject for lack of probable cause. There are experienced public servants resigning rather than compromise ethical standards. From Tony's perspective, two dangers are emerging simultaneously. First, brain drain. When experienced investigators, analysts, and prosecutors leave or are terminated, institutional knowledge walks out the door. These organizations cannot function at elite levels with amateurs. National defense and federal law enforcement are not entry-level training grounds for improvisation. Second, morale collapse. Even those who remain can become demoralized if leadership signals that loyalty to individuals outweighs fidelity to law. That corrodes culture from within. We discussed a particularly troubling issue: firing agents for executing lawful subpoenas in the course of investigations. Tony's position was clear. If subpoenas were lawfully issued and evidence lawfully pursued, retaliation sends a chilling message to future investigators. It suggests that certain individuals may be untouchable, that investigative caution should increase when political power increases. That is incompatible with equal justice under law. We also examined the role of grand juries. In Washington, D.C., multiple grand juries reportedly declined to indict certain politically charged cases, signaling insufficient evidence. When prosecutors repeatedly present cases lacking probable cause, that is not just a strategic miscalculation. It can become an ethical issue. Prosecutorial discretion is sacred ground. It is the power to decide who faces the force of the state. Misuse that power, and you undermine the legitimacy of the entire justice system. Tony emphasized something important here. Accountability must exist. Not vengeance, not political score settling, but lawful accountability. If unlawful actions occur, they must be addressed through constitutional processes. If misconduct goes unchallenged, it invites repetition. That philosophy translates directly to his priorities in Texas. His first priority as Attorney General would be cultural restoration, reinforcing that the office serves Texans, not party structures. That means dismissing purely political lawsuits and pursuing cases that materially protect state residents, regardless of who occupies the White House. He argues that billions of dollars affecting Texans have been left unchallenged because of partisan alignment. If a Republican occupies the Oval Office, some actions go unscrutinized. If a Democrat does, litigation intensifies. That asymmetry undermines credibility. His commitment is that litigation decisions would be principle-based, not partisan-based. Second, he wants to rebuild litigation capacity. He describes a similar brain drain inside the Texas Attorney General's office. When skilled civil litigators leave because cases become ideologically driven, the office loses its ability to handle major civil enforcement matters internally. That leads to weaker representation and diminished leverage. Rebuilding talent means attracting attorneys who value professional reputation over political theatrics. Immigration, of course, remains central to Texas politics, but Tony framed it less as a slogan issue and more as a constitutional boundary issue. States have roles. The federal government has roles. When federal dereliction harms Texans, litigation may be appropriate. But when enforcement crosses constitutional lines, that must also be checked. The consistent theme is institutional integrity. We also touched on history, specifically the temptation in American politics to move on from misconduct for the sake of stability. After Watergate, President Gerald Ford pardoned Richard Nixon in the interest of national healing. After more recent controversies, similar arguments were made. Avoid prosecution, rebuild institutions, look forward. But the risk of skipping accountability is repetition. When consequences are absent, deterrence evaporates. Tony's position is that lawful accountability and institutional rebuilding are not mutually exclusive. In fact, they reinforce one another. Toward the end of our conversation, he outlined what his campaign needs: intellectual support, grassroots energy, financial backing, and people willing to prioritize integrity over party identity. Running statewide in Texas is not inexpensive. It requires organization, fundraising, and coalition building across diverse constituencies: urban, rural, border communities, business sectors, veterans, law enforcement professionals. Texas is not monolithic. It is a complex state with competing interests and national significance. And here is the broader context. State attorneys general have become major players in national policy disputes. They sue federal agencies. They challenge executive orders. They coordinate multi-state actions that influence Supreme Court precedent. The office is no longer confined to consumer complaints and regulatory defense. It is a frontline constitutional role. That means whoever occupies it shapes not just Texas law but potentially federal law. As we wrapped up, I reflected on a phrase I often use: justice matters. Some critics argue that justice is an illusion, that power always prevails. But if justice truly did not matter, people would not react so viscerally when they perceive its absence. The anger many Americans feel right now, whether about federal agencies, political prosecutions, or perceived corruption, is evidence that justice still matters deeply. The debate is not about whether justice is important. It is about who enforces it, how it is enforced, and whether enforcement is neutral. Tony Box's candidacy rests on the premise that the Texas Attorney General's office should be an instrument of constitutional governance, not partisan warfare. Whether voters agree will be decided at the ballot box. But one thing is undeniable: his background spans battlefield command, federal investigation, courtroom prosecution, and private advocacy. Few candidates can claim experience on all those fronts. The real question for Texans becomes this: do you want an attorney general defined by political combat or by institutional stewardship? Do you want litigation driven by party alignment or by constitutional analysis? Do you want cultural restoration inside the office or continuation of the status quo? Those are not rhetorical questions, they are governance questions. And governance, unlike campaign rhetoric, has consequences. So, as this race develops, with multiple candidates on both Republican and Democratic sides, the voters of Texas will have an opportunity to weigh experience, temperament, and vision. Integrity is easy to promise. It is harder to practice, but in positions of concentrated legal power, integrity is not optional. It is foundational. That's the conversation we had, and it's one worth continuing.